Now, Tara Oakley is one of the, I think she's the owner, I will talk about still, for Sentence Equality. They're an organisation who, almost entirely, as I understand, dedicated to providing Section 27 background or cultural reports. And they have written today, just published today, this morning, opinion piece that's been picked up by the Otago Daily Times. I'm sure you'll see it in other media today as well, saying that they are threatened, or Section 27 background or cultural reports are threatened as the National Party commits to removing funding for written reports. Now, as I said and explained before, Section 27(1)(a) of the Sentencing Act of 2002 allows an offender, and presumably an offender's representative, so the lawyer, but I mean they always say the offender, but obviously it won't be the offender, it'll be the offender's lawyer, to be able to submit a report, a background or a cultural report. Now, culture's part of that, as you would have heard me say. There's also family whānau and a series of other things as well. And there are professional agencies involved in New Zealand. Sentence Equality is one of them. There's another one, I think, called Section 27 Reports. In actual fact, that's the name of the company. So let's go and talk to one of the principles of Sentence Equality, why they are concerned that the government may move in this direction, and what, in actual fact, formative or positive role Section 27 reports actually play in the sentencing of criminal offenders in our justice courts. I introduce you to Tara Oakley. Tara, welcome to the show. Lovely to have you on.
Thank you, Michael.
Now, Tara, I've just read this morning, for the first time, your article is written with Rebecca Couples on removing Section 27 cultural reports. You're obviously concerned that an incoming National/New Zealand First/Act government will remove funding for them. I think it's part of their policy, in actual fact, of all three of them, that they've identified that, so your fears are probably well justified. Just before we go into the politics of it, can you explain how Section 27 got to be in the Sentencing Act anyhow?
Well, it was originally included in 1985 in the Criminal Justice Act under Section 16. And then when the Sentencing Act came into being in 2002, they rewrote it slightly, but it's effectively the same wording. And it was introduced in 1985 because of several reports that had come through to the government discussing how prisons were simply not working to reduce recidivism or to have any positive impacts on the prison population. The specific concern was Māori at that time, because Māori incarceration was growing at a greater rate, as were the recidivism rates at that time. And so they wanted to look at this whole idea, and there was plenty of international evidence that was used at the time, that community-based options of sentencing were preferable and were more positive. And so they wanted to kind of put out to the community what was available and how the community or whānau or family or church or whatever could support that person in rehabilitation outside of a custodial sentence. So that's kind of how it all came about. But as time went on, it wasn't being utilised. I mean, it was this really powerful mitigating tool that was sitting essentially dormant, because there was several reasons. I wrote a thesis on it, I did a bit of research, and there were several reasons why that was so. One was that the judges were wary of having multiple members of family come into the court and, present information which may or may not have been relevant, wasting court time. Also, the emotional aspects to that were uncomfortable for the judges. And at the same time, there were several of these, the nature of offending, it has a genesis in family trauma and dysfunction. And so a lot of these people didn't have anybody that could sufficiently represent them or were willing to. A lot of these people had already been, substantially harmed by the state and state care and had no trust for the system. So it was a twofold thing why it didn't work. And so it essentially sat dormant until around 2017 when these written reports came into being and the judges saw or were able to have the information that they needed to sentence effectively, because sentencing is about justice, and justice is about understanding what it is you're dealing with. And so these reports gave them a safe...
Tara, just to clarify for a second. So what you're saying was when the 2002 Sentencing Act came in, Section 27 was there. I've read it out this morning already. And what you're saying was that it didn't really become operative because it was convoluted and judges didn't like them because, as you just say, it could get very undisciplined and unwieldy. So the idea of a live presentation from family, yes, that's right. Well, in actual fact, I mean, gosh, you could waste an awful lot of time because I see under the Act the court must hear a person or persons called by the offenders under this section.
Yeah, that's right.
So
they can decide not to. They do have the option to not if they really do not think it's going to be helpful to the sentencing at all. But
right. But in 2017, that all changes with the new government. Is that because the funding now you could now get a written report from somebody who is professional like yourself to actually go... No. So there was... I don't know who wrote the very first written report, and I think it was prior to 2017. But in 2017, you certainly saw the rise of the written report. So there would have been... so lawyers before that would have been submitting affidavits and things like that towards Section 27 principles. But so this was, 2017 sort of, there would have been some prior to that, but 2017 saw the rise of the written report. And, law is, I'm sure you know this, but precedence, right? So once precedence is set, then we start to see, a build, right? So there was precedence set in and around early 2016, 2017 around these reports, So at what stage do they become funded, though?
I think that the option for them to be funded has always been there. So the lawyers have the right under an amendment to grant to us for any specialist report. So they're not funded under a special category. They're funded under that particular category. So the right's always been there for lawyers to do that. It's that there was a real that was something that could be done.
Okay.
The law did not change.
All right. The law didn't change, but somewhere along the line. There was a
legal precedence. I believe legal precedence began, and so there became a responsibility for lawyers to provide sufficient background information on their clients.
Okay. And you set yourself up in direct response to that sentence equity?
No, I wrote a thesis.
No. I understand you wrote a thesis.
2019, 2020. And then I went into that. Mm-hmm.
Yeah. So you started up sentence equity. There are sentence equality. Sentence equity, isn't it? You started
sentence equality.
Yeah. You set that up. There's about 7 or 8 of you, I think, that are currently employed. To write these cultural and background reports, yes?
So we're not effectively a company as such. We're a group, we're a collective. So there's no overarching business necessarily. We write within just under that umbrella. Yeah.
Okay. So who determines who writes what reports? There are, I'm looking at 1, 2, 3, 4, 5, 6, 7, 8 of you. You've got. So if a reporter comes, a lawyer comes to you and says, I've got a client, can you look at them? How do you determine which of the 8 of you will write that report for that individual?
We definitely look at the experience of the report writer. So if it's a high court or a court of appeal matter, it would go to one of the senior writers.
That would be you.
So there's me, or there's Dr. Juan Todi, or there's Rebecca Couples.
Yeah.
So we've been doing it for a while, and just with it takes a lot of practice to do these effectively. They're very comprehensive reports, and interactions with a real vulnerable cohort of our society. So so if it's high level offending, we'll prioritise who gets those. Generally, if it's a Māori client, we'll try and link them with a Māori writer. If it's a different ethnicity, often we have to research, so that might go to one of our anthropology or specialists, because they are more adept at doing that research.
And Tara, when you write these, because I imagine they take a bit of time. You've got to interview the offender, correct? And potentially a number of his or her associates, including whānau and
teachers.
Yeah.
Yep.
All right. So there's hours and hours involved in this. How much would an average report? How many hours would go into an average report that you're providing?
So we allow for 20 hours per report.
Mm-hmm.
We generally go over, but there's occasions where we go under, so we just do 20 hours as a general rule. Yeah.